Nowadays, it's very common for people to live together and not get married. And while that suits a lot of people, if you don't have a will, that could cause a lot of problems if one of you should pass away prematurely and leave the other person in a little bit of a pickle financially. Because a lot of people assume, especially living in Ontario, the rules are different in every province, but I'm focusing in Ontario where I actually am licensed. So, if you're common law living in Ontario and your partner passes away and they do not have a will, you are going to be locked out of the estate. If there's children or parents or siblings, they will all take priority over you. If you feel that living common law is fine, there's nothing wrong with that for your situation, but make sure that you and your partner have a will, a legal written will. And this does not have to come from a lawyer, but it's always recommended. But even if you each did a holograph, which is your handwritten will, not a will on the computer, but a handwritten will, it's better than nothing. As always, we prefer professional advice, but you as a common law partner need to know that your rights are not the same as a married person when it comes to dying intestate, meaning dying without a will. There are certain things you would be entitled to, such as sharing CPP benefits, pension, but not the estate. So if your name is not like a legal owner on the house and your partner had bought it and you moved in there and you've been paying into it, thinking that you actually have a contribution, meaning you at least own half, that's not the case if it's not written anywhere. The will is so important, and everything else that you have that's not joined but individually named will not go to you. So you want to seek out professional advice when you're doing your estate planning. First, you would talk to your financial advisor, and then from there you would deal with your lawyer and or the accountant to make sure that you're on board and understand your legal rights and your situation, so you don't find yourself up in arms having to maybe move out of a house that you've been living in for many years, or finding out you've got to buy out the children if you want to stay, and finding out also that none of the money, other than if you were left as beneficiary or successor holder on a tax-free saving, is going to you. People don't always check their plans, and when they have a different situation, they haven't updated to the new person that they're with. So if you're living common law because your spouse was actually still legally married to somebody else, find out, because that spouse might be entitled to the estate, and that's not what you want. So again, you want to talk to a professional such as your financial advisor and then a lawyer to make sure you're well protected, and also that you understand financially what's involved. This is Linda Levesque from Levesque Wealth Planning, bidding you a good day.